gentlemen, and welcome back to another What If video. My name is Viepia, and as always, it is great to have you. Today's topic is another interesting one, and the topic is: what if a manager is elected as shop steward? Will this election be considered a conflict of interest? And if so, is there anything that the employer can do to stop such an appointment? Now, in considering this, I will discuss the relevant legislative framework as well as two cases. In terms of legislation, we need to discuss the Constitution and the Labour Relations Act. In terms of the Constitution, Section 23(2) provides that every worker has the right to form and join a trade union and to participate in the union's activities and programs. This also includes performing the duties of a shop steward. Section 4 of the LRA gives trade union members a right to stand for election and to be eligible for appointment as an office bearer or official, and if elected or appointed, to hold office of that trade union. Section 5 of the LRA in turn provides the following: 1, that no person may discriminate against an employee for exercising any rights conferred by the LRA. 2, the section prohibits an employer from preventing an employee from becoming a member of a trade union. And 3, the section precludes an employer from acting to the detriment of an employee because of past, present, or anticipated membership of a trade union, or past, present, or anticipated participation in the union's activities. What is clear, ladies and gentlemen, is that the Constitution and the LRA does not exclude managers from being elected as shop stewards. The cases that I want to discuss: the first case is Fawu and another versus the cold chain. And in this matter, an employee who was a shop steward and a union office bearer was offered a higher grade position as an alternative to retrenchment. Now, in this case, the employer informed the employee that the alternative position is that of a managerial post, and that if the employee was to accept this post, he would have to give up his role as a shop steward. Quite an interesting approach. The employee in this case accepted the alternative, but he refused to give up his role as shop steward. Subsequent to that, the employer retrenched the employee, and the employee referred an unfair dismissal dispute, an automatically unfair dismissal dispute to the TCMA, and thereafter it was adjudicated by the Labour Court. Now, in this case, the court held that in terms of the Constitution, as we have discussed earlier, every employee has the right to join and hold office in a union and to participate in the union's activities. The opinion of the court was that if it was the intention of the lawmakers to make a distinction between ordinary employees and senior employees with regards to membership, then it would have done so in the LRA and the Constitution. However, no such distinction has been made, as I have pointed out. The court held that for an employer to deny an employee a promotion unless he surrendered his position as a shop steward would be unlawful. The court, however, said the following: what is clear is that employees who are appointed shop stewards still owe a duty of fidelity to their employers, and they could accordingly face dismissal for incapacity if they are prevented by their union activities and allegiances from discharging their functions as employees. Although an employee is entitled to stand for election as shop steward, if there is a conflict between that role and the employee's work responsibilities, the employee may be subject to disciplinary action or be dismissed for incapacity. The second case I want to discuss is the case of Imatu and others versus Rustenburg Transitional Council. And in this case, the Labour Court said the following: the employer cannot seek to infringe the employee's freedom of association, but may pursue breach of contract remedies should a senior manager, who is also a senior position in the trade union, not be able to serve the interests of his employer in good faith. The employee must still do the work for which he is engaged and observe the secondary duties by which he is bound under the contract. If he does not, He can be disciplined for misconduct or laid off for incapacity. So the courts are quite clear in this regard. As a shop, although you may be selected as a shop steward or entitled to stand for election as a shop steward, if there's a conflict between the role of the shop steward and your work responsibilities, you may be subjected to disciplinary action or even be dismissed for incapacity. Employers are also encouraged to consider the wording of the agreement between the employer and the trade union. In other words, for example, you need to look at if there's a recognition agreement in place to consider the wording of such an agreement. The reason for that is because although shop stewards are normally drawn from the bargaining unit or the constituency that they represent, shop stewards may, in the absence of an agreement stipulating to the contrary, be even drawn from any section of the workforce, even from managerial level. If the bargaining unit is properly defined, the approach is usually to specifically exclude management. But in the absence of such an agreement, as I've mentioned, the shop steward may be drawn from any section of the workforce, even from managerial level. So just in summary, ladies and gentlemen, an employer may not prevent a managerial or supervisory employee from being a shop steward unless that is specifically excluded in an agreement between the parties. However, as I've mentioned before, such an employee still owe a duty of good faith to the employer, and dismissal could follow if this common law duty is breached. Now, there's no doubt that following or allowing a manager to be a shop steward will result in practical challenges. Some of these challenges can include: one, the manager or the supervisor's role in a disciplinary and incapacity proceedings. In other words, a manager representing a fellow colleague or a subordinate where that manager was supposed to be the initiator, for example. That same manager or supervisor's role in wage negotiations that will result in a practical challenge, as well as the manager's access to confidential information. Now, it is advisable that these challenges that I've just discussed be regulated in an agreement, and that the agreement must include or state, for example, that in terms of disciplinary or incapacity proceedings, the employee, the manager, the supervisor, will not be allowed to act on behalf of or represent union members. Two, that in terms of wage or other negotiations, that he will not be or she will not be allowed to act on behalf of trade union or the trade union members. And in terms of confidentiality, that the employee will not be allowed to disclose any confidential information to the trade union. Now, just back to the representation in the disciplinary or incapacity proceedings. If the bargaining unit is not defined, and if there's not an agreement that specifically excludes a manager from being elected as a shop steward, this manager can be elected one, and if elected, there's nothing wrong in the manager still representing fellow colleagues on the basis that that fellow colleague is maybe at the same level as the manager or higher. The problem comes in where this manager is representing subordinates, and that is something that you want to specifically exclude from, or at least govern in terms of this agreement. Now, the question would arise, what happens if the employee now refuses to sign this agreement that we are discussing? What the employer can consider is, obviously, is there a conflict? Is the employee's duties as a shop steward in conflict with his or her duties as a manager? If yes, we know our court cases state that the employee may be subject to disciplinary action or even to be dismissed for incapacity. But what you can consider, ladies and gentlemen, is by considering a demotion into a non-managerial position or non-supervisory position, which will obviously be seen as an alternative to dismissal. So this brings us to the end of this video. I hope it was useful and that there was some interesting points made in this video. If you have any questions in this regard, please do not hesitate to contact us. As always, thank you for watching. I will see you next time. Bye-bye.